Yeah, but I think those issues have been addressed.
Does everybody have a copy of it?
No.
You want to make it quick?
Of
It's
this?
the one stamped April 9th,
Yes,
correct?
that's
Yeah.
correct.
Can I
yes.
ask a question? Is that the one that's on the website?
Correct.
Yeah,
Yay. Somebody asked me that.
glad you're happy.
Yay.
Okay.
We ready?
We don't have to go long.
Yes, we are.
I don't think we have to go long.
Yeah, but we're good. We don't have to go
Okay,
long.
good morning, everybody. I'd like to call the executive committee to order. Roll call.
Mr. Samuelson.
Here.
Mr. Benson.
Here,
Mrs. Labuda. Ms. Vetter.
Here.
Mr. Ruiz.
Here.
Mrs. Geiger.
Here.
Mrs. Edwards.
Here.
Mr. Steingart.
Here.
Mr. Sorensen.
Here.
Okay, the purpose of today's meeting, of course, is to review the new local law, the ethics law. We did this once before, and we went through it line by line. So I think what we should do today is, if anybody has a specific change or question on the law in any way, to bring it up. Ideally, if you have it in writing, it's going to be the best way to do it, so that Cheryl can take a look at that. Also, I think that anything that comes up at the table today, we will vote on in a formal vote, and so that we can formalize it today and be done, so Cheryl can make the edits and amendments to the local law. So, that being said, who would like to go first? Who has anything that they would like to bring up at this time? Are there any changes or amendments or questions about the ethics law?
Okay, I am looking at
Cindy.
page 4. That's me.
I think we all knew that.
Page 4, if we look in definitions, okay, lines 73 through 76, and the change would also be inclusive of lines 77 through 79. Okay, in reading the way the current document reads, it says, "These individuals shall be determined annually by the appointing authority and thereafter listed by the chairman of the legislature prior to February 28th of each year. The list shall include office title," I'm not including that. "The initial list of local officers and employees shall be determined by resolution of the county legislature within 60 days of adoption of the law." So in reviewing that particular section, I felt that a definition of the appointing authority was not clear. And so I wanted to clarify it to read, "These individuals," meaning individuals that are subject to the ethics law, "shall be determined by resolution of the majority of the legislature within 60 days of adoption of this law and be attached to the law, and thereafter only additions to this initial list will be reviewed by the legislature annually prior to February 28th of each year." And in clarifying that particular section on who the appointing authority is and who's devising this list within 60 days, and the clarification ensures that the positions and entities subject to the ethics law, which will be a list of those that will be under the law, remain as determined by the majority of the legislature and not subject to change on an annual basis by an appointing authority, which, hasn't been identified in the law. So I think basically what I'm proposing is what the law already says. I just clarified that the list won't change. It won't be subject to change on an annual basis by an appointing authority. So I have it in writing for you.
Okay, does anybody have any questions or comments on that?
Well, I think
Byron?
it says someplace in there that the appointing authority is the legislature. The only problem I have with what you're saying is, it should be the majority, but I hate to, we'd have to change the local law. We've determined down the road, or actually after us, another legislature determines that they want to take somebody out because it's really not necessary. You're gonna have to go to local law to do that.
Well, I think, in moving forward, I think we all realize we've reviewed this ethics law over and over. At least I have, and I know, I'm hoping that we all did. We've been in committee, we've discussed it. It's not a perfect law. I mean, there's things that I think in applying the law moving forward that are gonna have to change. However, I feel that's covered because the next steps in the process is, once the law is passed, an ethics board will be set up and put in place. We'll appoint a new board of ethics. And in the document itself, under duties of the ethics board, it states that the ethics board will be submitting recommendations for any change to the law. So moving forward and applying the law, the ethics board will cover any changes that need to be made. Because I anticipate, I reviewed this law and what my intent was in reviewing the law was just to send a message that we're committed to ensure public trust in government by the people that we serve. Not discouraging people from serving, but putting in place a new level of accountability for those that serve the public. So I think
Cindy,
changes will be addressed in, as
In
we move
time.
forward, right?
I had no comment as to your suggested language, it sounded fine, but in thinking it through, if you want within 60 days of adoption of the law to then identify pretty much the bulk of the individuals who will be subject to the law, that is a very substantial portion of the law. So you're really adopting a law without any teeth because people don't know who's involved in
Well, that's
this.
why if I understand correctly, within 60 days of passage of the law, those that are subject to the law you and I had that discussion about the list of disclosure
By resolution,
by resolution.
because
Right.
it doesn't impact the law. If you want that list actually made a part of the law, that's substantial. Do you know, Sam, am I articulating myself well enough? It's one thing to go by resolution, where you guys could amend the by resolution anytime. It's another thing to actually identify all the individuals who be subject to the ethics law, but leaving that a blank and adopting the ethics law.
What I think she's saying is she wants to adopt the law and only make that list of individuals by resolution. That way, if you want to change that list,
No.
No, she wants it a part of the law.
Well,
That's the way what she's stating.
The way I look at it is that the list of entities and positions of people that are gonna be under the ethics law shouldn't change. It shouldn't be a fluid document. As you move forward, if there's entities that are no longer in existence,
Right.
that doesn't matter. No
Right.
change needs to occur because there's no people on the board. If there's additions, we form a new economic development entity. That can be an addition to the list.
I
But the
am
list
agreement with you.
wouldn't be fluid, the list would be, and not only that, but those that are subject to this document need to know who they are.
Exactly,
in
and that's why you
reviewing-
can't adopt the law and not let anybody know who they are, who are going to be subject to the
So
law.
when do we do that?
Right now, if you want to go
So-
forward with the timeline, or you have, I think this is so substantial that you can't adopt the law with the hole in it, and
So
It-
how come
it's
that
not
was
like
never
you're-
discussed
It
before?
was.
it was, because it was by resolution, and you've
Right.
asked that it not be by resolution, but it be attached to the law. In order for it to be attached to the law and be meaningful, I don't think you can have a public hearing on the law or
But it is
adopt the
by
law.
resolution of the majority of the legislature.
If it's by resolution, then it's not a part of the law.
So,
So just.
Wait a minute, hold on. Cora's got her hand up, let's.
Well, there was an email exchange that I had with Linda Levine, remember, about the fact that there was this disclosure list, and the day it had to be filed was May 15th, and guess what? We're having the public hearing May 16th.
Right.
What disclosure
Well, the
Those are the
financial
lists-
disclosure
financial
under the
due,
prior
right?
law,
Yeah,
under the current local law.
Right.
Because it's a requirement and the date was May 15th it had to be filed by, yeah.
But that's
But that
every
wasn't
year.
an
Every year,
issue.
Cora.
It's every year.
Right.
Well, that's why this is so important.
But this section, isn't necessarily pertaining to financial disclosure.
Say that again?
This section doesn't necessarily pertain to financial disclosure. This section is defining those county officials that are subject to the law in
Right,
general,
right.
which means the prohibitions. They may also be required to file financial disclosure under the law as well. But this is looking at the law as a whole and regarding who it pertains to and who is prohibited from certain conduct.
And they're two separate.
Right.
They could be two-
disclosure,
they could
but
be
they
two
could
separate
mirror
things.
each other
They
as
could.
well.
They could.
Exactly.
Yes.
So in moving forward, we need to formulate that list, not to be fluid document that every January
It's not
gets
a fl-
additions and deletions.
I mean, Annie can speak to this. That list that you go by, right, it doesn't change much. Your
Well, it
financial
shouldn't-
disclosure.
It basically shouldn't change at all
Well, changes
unless.
to add a position.
Just to add.
Yeah.
Right.
Or if there's no longer a
Right.
position, she doesn't
Correct.
send the financial
Right.
disclosure out.
Kitty?
So I would suggest that we take the page that talks about the resolution of the executive committee, list of public officials for the financial disclosure, and just put those people in there.
It's, well, if I understand what you're saying, the people that have to file financial disclosures, it's like, I don't remember that in math, union and intersection. There are some people that have to file financial disclosures based on their actual positions within the county government. And then there are other people, and that world of coverage of the law is much broader and much bigger than financial disclosure. I think, so
Basically,
I-
what we're attempting to do is to name the people. and
The
you're
position, you're not
stating-
naming
The
people.
Positions, you're stating that we need to name them if we're gonna put it in here now. So I wanna name them, and so I wanna use the list that we have for financial disclosure as the names.
As the position.
As the positions.
I try to get, I think, to the crux of what they're trying to say,
What
instead
they
of going
are trying to
around,
say.
and I don't mean to interpret if I'm wrong. They want to accomplish two things. They want it part of the law, and they don't want the future legislature to be able to change it without changing the law. And they want the list fixed now as opposed to the resolution. And I have two concerns. I don't think the list is gonna change very often, and it
No,
hasn't in the
it shouldn't.
future. But I think we're tying our shoes, and, this is a living document. And by making it more difficult for people in the future, first of all, we won't be here, number one, and I think it's a big mistake that we're handcuffing them without going through a large procedure where, to be realistic, I don't think this is gonna be an issue. The list comes up, we're gonna go over the list, it's gonna be part of the resolution, and it's really not gonna change that much. I think what you're trying to do is make sure it doesn't change for the future, and I think that's a mistake. And that's, I think, the crux of what you're trying to do. And correct me if I'm wrong.
Well, I think you've got it partially right, but the main piece to me is if we're doing an annual review, oftentimes things get tabled and put in the back burner until it gets done. So then the annual review might get put off for too long, where if you have that list in the document, since we know that it's not gonna change that often, then have the list in the
But-
document.
Kitty, in all due respect, that you're wrong about that. Every single year, the list of the people that are elected officials in the county have to file their disclosure form. That does not change. The only time it changes is, I think this year, we added a new Ford guy, the guy we just hired. That list, by law, every year, we must fill out those financial disclosure forms. So
Right.
it doesn't change unless we add a name.
But where's the,
So,
where's the list
so you're
of
saying, you
those
say
that are-
That's not
back
the
burner,
list
there's
she's
no back
talking
burner.
about.
By law, we must fill out those forms.
No, no.
That's not the list she's talking about.
Yeah.
I'm
Yes.
talking about this
There is no
paragraph
list.
here on page 4, and this paragraph says determined annually, and I wanna get rid of determined annually. I wanna put those titles in there, and not determine it annually. I wanna have them in there as part of the code.
Cora?
Yeah, my understanding is that the way the law reads right now, there is no list, right? It wasn't in 98, and it wasn't in 2012, and it isn't in the 2013.
I've never seen a list.
Right.
I've
So,
not-
so we're introducing this concept, and according to the language that Cindy wrote, and correct me if I'm wrong on your language, these individuals shall be determined by resolution
Right.
within 60 days of adoption of this law.
That's the
and-
language she didn't want, because you didn't want it by
No,
resolution.
that is what,
No, that's what I,
that-
here,
that-
here's.
That's what
That's
she
what she
wants
did
it
I
to
have it in
be.
writing.
that's what I tried to
But
say
that's what was
earlier.
in the law.
We wanna get rid of the term determined annually. That's the crux of what we wanna get rid of.
That's all.
And
And
Yeah,
just
but
defining
then
put
it
it
would have to
within
be a
authority.
part, but it would have to be a part of the law to not be determined annually. If it's by resolution,
resolution.
it would be
Right.
reviewed on a yearly basis.
Or
Sam?
not.
Well, that's the point, is that it gets kind of shoved to the back burner,
It wouldn't be
as opposed
subject
to.
to change.
May I suggest a compromise? If you want the list as part of the law, as opposed to a separate resolution, you're not going to be able to enact the law till you all agree on the list, because the list itself will become a substantial change. You'd be enacting a law that isn't complete. I understand Cindy's point that she doesn't want frequent changes to that list. Presently, we don't have a list by title, we have a list by general overall criteria, which is the normal way they do it. May I suggest that one thing you might want to consider is leave it that you will put it in a resolution within 60 days, but instead of saying reviewed annual, provide that the resolution may only be changed upon recommendation of the Board of Ethics in the future, and then action by the county legislature. So it would have to be,
How about this?
it would have to be a two-step process. It wouldn't be a constant annual change. It would mean that you'd have this separate board that has been impaneled for solely this purpose, making the recommendation to the Board of Legislators. But you could then change it as a part of a resolution without changing the law again. I think that might accomplish your purpose in terms of trying to keep stability.
Stability is important, we don't want the.
Does that make some sense to you, Cindy?
I just would have to clarify that. So, the individuals shall be determined by resolution of the majority of the legislature within 60 days of adoption of the law.
And thereafter only changed
And-
upon recommendation of the Board of Ethics, and thereafter adopted in a subsequent resolution by the Board of Legislators.
So, and only change by recommendation.
I'm concerned that you're abrogating the authority of the legislature to the Board of Ethics. I would say upon maybe
Advisory recommendation.
both.
Based on what, I'm sorry.
I think that the legislature, in my opinion, you have the right and the authority to determine who should be subject to the ethics law. I'm not
We shouldn't
sure,
have to wait for the Board of
I'm not
Ethics.
certain
How about-
that
Well,
you
they're gonna be
should.
determined by resolution of
concurred
the
in by the
majority of
Board
the
of Ethics.
How
legislature.
about, I have another suggestion. How about that, I think you're concerned about the list every year changing. What about if we have the list will remain the same unless a resolution by the majority of the legislature is done by a certain date, the third week of January each year? So it's gonna stay the same unless we pick a date in the year that,
Or it could just be a continuing resolution, you don't have to say anything else about it, it's like the financial, this is what I was going to bring up. And these were my markings, but I think this is the draft resolution that Annie had, that you looked at and you adopted for financial disclosure. You adopt this every year
You don't
for
have to.
financial disclosure, you don't have to, it's there. If you hadn't adopted this resolution this year, Annie would have used the resolution from last year, and just knowing that there might have been other people that had to file, would have sent out the letter. So it's an ongoing resolution. So this could be, your list could be a standing list by resolution. And it's not something that you would really have to analyze every year unless it's come to your attention that there's a new position or an old position, or, you know, you want to have your board consider it. It doesn't have to be an annual resolution.
Well, let's face it, I mean, if we're gonna pass the ethics law, and those people are gonna be subject to the law, they have to know who they are. I would want it spelled out who I am, correct? So, for example, like Kitty had said, this disclosure list spells you out.
It
There's no
does.
doubt about it.
And that's correct, and that is, it's based on state, you know, state law too.
So when the law is passed, wouldn't it make sense to make sure that those that are subject to the law review the law and understand the law and realize that their name is on the list, not just,
Sure.
Right.
But that's why the language is the way, I'm in agreement with you. My concern was that if you wanted to identify the
Title.
positions, the titles,
There you go.
into the law, then it's an incomplete law. If you want to.
well, then the alternative to doing it that way is to adopt a list. It could mirror disclosure. Adopt that list within 60 days. And that won't change unless there's additions. It shouldn't, it doesn't have to. Names don't have to come off of that. You know what I'm saying?
Right, and I use this example. We identify for financial disclosure the 1st through 7th assistant district attorney. It's just the way the resolution reads, it's not a big deal. You don't have to put that. You could say district attorney and all assistant district attorneys, county attorney and all assistant county attorneys. You don't have to number them, so you wouldn't have to modify
Well, that's
in that
coming within
regard.
60 days of passage of the law. We'll have that discussion about the list.
Well, if it's not such a big deal, why are we discussing it?
Well, no, I'm just explaining that there are ways, it's specified for financial
We have time for that.
disclosure.
We have
I'm just
60
saying, if
days.
it's not such a big deal, why are we discussing it? Apparently, it is a big deal, we have to discuss it.
So what's the alternative then? So, the legislature formulates the list within 60 days, not to be a fluid document that's changing on an annual basis. Any additions to the list would be made, what was your recommendation?
Well, if you want to pass the local law now, and then make a list separately, that list would have to be in the resolution. If you want that list to be in the local law, you're gonna have to wait till that list is complete before you can enact the local law. Because otherwise you'd have a local law that says, this group shall not, and you don't list the group, you don't have a complete local law.
Okay, so they can be determined by resolution
They
of the
could
legislature.
be, and then what I suggested, if you want to create additional stability, is say, either on the recommendation of or concurrence by the Board of Ethics, so that it would take the vote of both the Board of Legislators and the Board of Ethics to change the
We
list
wouldn't,
of
we
who is
shouldn't need to
subject.
change the list, but additions would be done.
I've
Well,
used
sometimes
the
there
word
are
change.
positions that are eliminated, so you want those,
I use the word
that's
change.
all. No, they don't have to, but that's all that's being
We
said.
might in the future decide to take something out, I don't know, but I use the word change to be broader. It would probably be addition.
Just for purposes of conversation, I'm not suggesting this. Do you all absolutely want a list of individuals who are subject to the law to be identified?
Yes.
Or, I'm
I'm
asking,
sorry.
okay. I said just for purposes of conversation because as Cora mentioned, it's not identified now in the,
Correct.
okay, so
That's a problem.
that's a question. Do you want a list, or do you want the identification of these individuals set forth in the definitions to suffice?
If I was sitting on a board, I'd wanna know who I am.
Well,
Well, if you
Is
read the
my-
law,
is
you
my name
should.
in there?
This is-
Am I right or am I wrong?
Again, it's not names,
Cindy-
it's positions. It's not individuals, it's not people, it's
I know it's
positions.
All right, I was just
Jean-
raising it as a
But
point
if
of
I'm
conversation.
sitting in that position, I wanna know that I'm subject.
Gene,
Yes.
it's not even positions. I think what
Same
Cheryl
thing.
Could we
is,
keep on one?
what Cheryl is trying to suggest is, the present law talks about general criteria. It doesn't talk
understand.
even about specific positions. One of the problems about putting in specific positions is you're gonna miss something. You know, it's inevitable. When you talk about general criteria without, you know, it's saying this applies to all car companies or this applies by brand, you'll miss something. The present law is broader in effect than this. So that's up to you, but you ought to be aware of that.
Kitty?
I would like to have it a hard and fast list.
Okay.
One of the reasons why I think a hard and fast list is important is because the annual review will allow for that to grow and or diminish in the future. But we need to start with something, and we didn't have it before, and therefore it was a little shaky as to whether or not people were, the position was on the list or not. I'd rather define the list now so that it's not shaky, so that people know if you're sitting on that board, you are subject to ethics.
Yes, thank you.
That's fine.
And
Thank
that's
you.
why I want that list now.
Again, I just
And then
raised it
the
just for a
annual
topic
review
of
can
conversation.
Well, we
make
have
that
until the 16th,
adoption
right?
in the
No.
future.
We don't.
No.
This is it. Do it.
We have 60 days after.
We have to have it
Before
Put
a
it-
public hearing and amend the
version.
local law, that's the
Before the
It says
16th.
at the end
Right.
of this document,
With the
right
list.
at the end of this document,
I know.
No.
No,
She didn't say
it has to be
It has to,
done by
when's
the
the,
That's-
Be here with the resolution on the law.
Okay, hold on. We,
Cindy would-
Sam, hold on,
I just
hold
want,
on. Let's go back to one
Cora-
place again.
Cora's raised a question, and if you were to
Sam?
continue with the schedule as proposed, by the 6th, I have to have the final version of the law on your desk.
Monday.
Okay, so all agreements have to be made today, basically.
We can always make an addendum to the
Yes.
law, can't we?
You can amend the law, after the law is adopted.
Once
Hold on
we-
one
Hang on.
second. Sam,
Hey,
Kitty, Jean,
sorry.
thank you. Could we keep the conversation to one conversation at a time, please? Cheryl, please.
You can amend the law once it's adopted. The reason why I brought up this concern was because the list it is the bulk of the law. You can't, if you wanted it to be part of the law, you have to spend the time, which only means that you'll have to change the date of the public hearing. If you want to spend the time to identify the individuals, to attach the list as an appendix to the law, and then there it is, then my recommendation is maybe if there's other issues to address, great, and in the meantime, you can get a hold of the resolution that was just passed for the financial disclosure and take that as your base for discussion on the county officials who will be identified in the law, and go through it. And that, because that's what you're ultimately going to have to do. You're going to have to identify each of the positions that are going to be subject to the law.
Cora?
so the consequences of not having a list in is what you said at the beginning, is that you have a law with no teeth.
You don't know if you want to identify the people to benefit the people who are going to be subject to the law, you can't adopt the law without identifying the people. If you, period. And that is why I raised the fact, do you want to identify the people, or do you want to just leave the language of the law?
Well, we can still identify the people within 60 days of passage of the law.
You
Can't add it
can
to
by
the law.
resolution.
That's exactly what I have.
Right, but then it's not
resolution
a
of the
part of the
legislature.
law.
That's fine. I understand that piece.
Oh, you do?
understand.
Okay, so
Yeah, that's what I
okay.
tried to
Sam
say.
just clarified that.
steps on.
But that's what it, okay, that's.
Okay, so now
I'm
is
totally-
everybody on the same page?
Yeah.
That it would be by this list will be made within 60 days of this law passing, at which point that would be put into a resolution passed by the legislature, and it doesn't have to be reviewed on a yearly basis, but if it needs to be, it could be.
Well, can I just read this then? These individuals shall be determined by resolution of the majority of the legislature within 60 days of adoption of this law, and thereafter, only additions to this initial list will be reviewed by the legislature annually prior to February 28th of each year.
I wouldn't, I'm gonna take your language if everyone agrees to it. I just wouldn't limit it to additions, maybe just say changes
Changes.
too, because you may take people, they may
No, you don't need to take anybody off the
You
list.
may,
Yeah, you may, there may no
need to.
longer be an entity, so you'd want.
Right, but the people aren't there.
Yeah,
So
but
why
you clean
did-
up
But
your
then
You
it's
want it
still
to be
part of the law,
accurate.
or go to the resolution.
It's a simple thing, but I would just say not just additions. Well, it's up to you, I'm not,
For
you know.
example, Cindy,
Before, would you, yeah.
Cindy, you have a title called ABC position, right? And it's in the list and it's in the financial disclosure. But say like the ABC position's done away with, they changed it. They're making it XYZ.
For example, what,
So we gotta take ABC and change it and put the XYZ position.
no, look, let's keep it simple. Cindy, 2 years ago, Cindy, in the 2009 budget, we eliminated the fraud investigator. A couple months ago, we reinstated them, so then Anne Marie add them to the list.
Yeah, that would be an addition,
That's-
no problem.
I'm saying, but we eliminated them from the list when we eliminated the position, and then now we just added them on, so that's a typical example of how she does the list.
Let me ask a question. If you don't remove them from the list, what happens?
Well, you have the irony, if you look at your current law refers to a state agency that doesn't exist,
Right.
which was
Sam, hold on one
abolished a number
second.
of years ago.
Cindy,
It
Cora, are
becomes
you-
ludicrous.
Sorry, Cindy.
The current law refers to a state agency that doesn't exist anymore. It was based on a state agency that doesn't exist.
Well, if it's there
So
or
of
not, it's not gonna
deletions of
change anything, it doesn't
non-existing
matter.
entities, there you go.
The only thing that could happen that you'd want
There you
it,
go.
that you may change the authority of a position that may no longer need to have this,
Could
the ethics, so.
That's why I just said changes.
just
I would leave
changes.
I would
changes.
say only additions or deletions of non-existing positions or entities, and then we got it.
It's up to you. You have to
Basically,
vote
it's the
on
same
it.
We
thing,
got it.
changes is just shorter. It's the same thing, it really is.
I would recommend, because Cindy's gonna give me her language, I would recommend that Cindy, you read to your colleagues the changes that you wish to have made to that section, so everybody hears it, and you all discuss it and vote on it, so that we know leaving here, the language that Cindy's proposed is good.
You have it in writing. Do you all have it, is this the change here that you guys are looking at?
It's a bunch of things, but
Could
Well, you
we
have-
all have a copy of it, so that we know what we're talking about?
Good
I
idea.
can make copies
It's
if someone
coming,
gives it to me.
it's coming.
It's coming.
Yeah, we're gonna discuss it, yes.
Well,
Do we have a copy of it, thank you? Yeah.
Christmas.
well, why shouldn't we all have it in front of us? You all have it, I don't know.
Andy's gonna make copies.
I only have a copy of what was there before we made any change.
Yeah.
What you
Okay.
gave me.
Okay, these individuals shall be determined by resolution of the majority of the legislature within 60 days of adoption of this law. And thereafter, only additions or deletions of non-existent entities to this list will be reviewed by the legislature annually prior to February 28th of each year.
Everybody good with that?
Did everybody hear that? Kitty? Sam?
I just want everyone to be clear and say, yes, they're good with that, so that I can.
Okay,
insert-
so let's call a vote on it. So is all in favor of the,
Do we have,
You're not a voting member, sorry.
I know, you should be able to.
can we vote with, with?
If you wanna hold it a
Yeah.
minute, that everybody.
Yeah, we're on-
can
we're
copy
Yeah,
it.
recording.
Annie's going, she'll be right back.
okay,
Read it one more time and then we'll vote on it.
These individuals shall be determined by resolution of the majority of the legislature within 60 days of adoption of this law, and thereafter only additions or deletions of non-existing positions or entities will be reviewed by the legislature annually prior to February 28th of each year.
You
I have
can't,
a- I have a
add
problem
a
with that.
non-existent agency.
I don't know.
I have a problem with that. because-
Some economic development.
I just said that.
Take it off. It's not existing.
Yeah, but you can't add one. The way you read it, you can add a non-existent agency.
Oh, only additions or deletions.
I'll let you clean up
missed
the
the word.
language.
Thank you.
No,
Lori.
I'm not touching the language. You are voting on the language, I am not touching the language. So if you're not happy with the language.
Okay, hold on, everybody. Annie, Kitty, what do we,
I'm suggesting that since this is a fluid document that we're trying to everybody see, instead of running in and out of the room, and I'm not the techie person, I think you could type it and get it up on the screen that everybody could see it at once.
No, it's coming down, I just,
Since we're
pass that
looking
down,
at
Ira,
changes.
please.
No?
Scott.
Okay.
Unless
Sorry.
they can get someone in here in 2 minutes.
Thank you, Amy. I don't wanna muck up the works here, guys, but I don't know that if you've forgotten someone within 60 days, that you wanna
Have another,
wait and not have them subject to the ethics law until next February.
Yeah, we're gonna review this, I've already reviewed this extensively, so I think 60 days gives us time.
No, I understand that, but if you make a mistake, I'm saying, I don't know that you
But the
wanna,
current law, the way it's in place, doesn't identify those anyway.
I'm with you.
Right.
I agree with
So we're
you.
better than we were in the
Cindy,
past.
I agree.
Okay.
Listen to what I'm saying.
I understand.
After you adopt that resolution, say you forgot to put the assistant county attorney on there, by mistake. That means I'm not subject to the ethics law until next February. I don't know that you want to do
That's okay.
that, so you may want to provide some language for correction.
Okay, I'm gonna read it again so we can vote on it. Okay. These individuals shall be determined by resolution of the majority of the legislature within 60 days of adoption of this law, and thereafter only additions or deletions of non-existing entities or positions will be reviewed by the legislature annually prior to February 28th of each year.
okay. There are problems with
With
that,
the
so
language.
Yeah.
would you, Sam, could you take a look at it and, they're not major things, could you
Well,
see
except
if
we
you
all
can?
agree, that's fine. Just write it so that it's legal.
Right,
I mean,
but
nobody's
Yeah, write it so
disputing,
it's
just.
legal.
that's what I'm saying, if Sam would put it into language that makes sense.
Well, I
and-
understand what you're saying. And I think 2 commas will correct.
Whatever it
the
takes, could
grammatical
we-
problem.
The only
Get to
concern
that.
I have is that the positions, with the way it's worded, if the position stays the same and the authority that that person has changes, that you don't feel he no longer has to be under this law, it's not an addition or a deletion of the position, just a change, and you won't be able to take it off with that wording.
The title would have to change if you change your job description.
And then it would
The
be
ti-
addition. Yeah.
Well, for civil service, but there are some other positions, like mainly management, that would be subject to this,
Why?
that are not subject.
You
to
can
this.
accomplish the same thing by just putting in changes, not additions or deletions, just changes.
The very second word, individuals, I thought we said we don't.
Yeah.
Position.
It
Positions.
shouldn't be, it should be
It
positions.
should be positions,
Right.
absolutely.
Yes,
absolutely.
I
I
think
think
we
that-
all believe,
that was the
agree in the
language in the law, I
concert,
believe.
concept, maybe make changes that we could all agree on.
Well, that's what we're trying to do. Sam is gonna put it into a form, we'll look at it, and we'll vote on it.
When are we gonna do that? Today?
Right now, right now.
No pressure.
Okay, talk amongst yourselves, I'll give you a topic.
And then the final, whatever you guys vote on today will be filed with me by Monday, May 6th, correct?
Well, that's why I was mentioning that.
Well, Sam's working on it, why don't we
And
go on to the
everybody.
next one?
Well, but there was an inherent, there was a piece in here that was brought up, and that's, you know, identifying the date. I think Cheryl makes a very good point, of putting a February 28th date on it. Do we really want to do that? If there is an oversight or a mistake, do we not want to be able to address that for a year or till
No,
February?
I think, look, as
before
an
tw-
elected official, if somebody's deleted by mistake, no, they should adhere to the same rules that I do and everybody else. No, it should be immediately. If you find the mistake, it should be addressed. Why should somebody go a whole year and not have to do that? That's not right. Because the name was deleted? No.
And it is an
Nope.
election year for some elected.
Exactly, so no, that's not right. Nope.
Right?
Cindy, what are you trying to accomplish by having a date in there as opposed to not being able to do it at any time?
By having a what?
A date in there, what is your goal in trying to do that?
That was from the original law.
But I'm saying, do you have a reason that we shouldn't be able to change it at any time? That's what I'm asking.
That's making it better.
Yeah, I think it's better if we review it annually.
No,
What
it
if you
makes
miss
it better
somebody and you
once
can't
you
have
know there's a mistake, that you fix the
That you can
mistake.
fix it then,
Immediately,
rather than
yes.
have to wait.
So I'm
To that
asking,
date.
what's your
Well, that,
reasoning
that
for
I,
doing that?
well, I didn't do that, that was in the law, that was in the law.
Okay,
You
but
don't have a
we,
problem with
I
taking it
think-
out?
but we're writing, hold on, Kat. We're writing the section now, we're rewriting the section now, so we could take it out.
Right, Sam is doing
Okay.
Wanna ask this body if we could next month spend this much time going, talking about economic development.
So Sam, would you
Well,
Get some money
leave
in
that,
something.
the date
are
out
you
of that? or-
is it the intent of the board to mandate an annual review of that list? Is that what you intend to do?
it. No, because the.
I'm asking the
sorry.
question for a reason, because that's what the language here does do. It requires, it really requires you to review the list each
Right, it
year.
does.
So, let me just understand what you want to accomplish, then we can put it into words. First of all, we're not going to attach it to the law, we're going to reference it to the law. You can't attach something to a law.
Right, that's
Um,
everybody.
If what you really are trying to do is to say that this list is going to remain stable and not be changed unless and until the board amends the resolution, and the resolution will remain in effect forever.
There's no sunset on a resolution?
No sunset
No.
on the resolution. Is that what you're trying to do? Because, let me take two instances. Let's assume you come up with this list in 60 days, and 10 days later, you discover, oops, we missed something. We want to add to the list. You should be able to do that, and I assume you want the ability to do that. I also assume that what you want is that if something doesn't come to your attention which requires a modification of that list, that you know it's going to remain in place, period. There's not going to be an annual
Yes.
opportunity for people to come to you and say, I want to be off, I want to be on, I want this, I want that. You want to know that that list is going to remain stable until there's a reason to make a modification to the list.
Yeah.
Is that what I'm hearing?
Yeah.
Yes.
Okay. If that's what it is, let me take a couple of minutes and see if I can come up with something that expresses that intent.
Linda?
Linda.
Linda?
Sam, just before you do that, I just want to point out to you that there, you know, I don't know if this list is supposed to be all-inclusive of who is considered a county official, but if it is, there's two other sections after that list comes up that comprise the county officials. So you may want to put that at the end of the section of the definition.
And what I was also going to suggest we do, because you really want to try to be as inclusive as you can. I think when you come up with the list, you've got some general criteria in the local law, the way the present local law has it. So what you're really saying is, this is the general criteria. We've got a list, but if there's anything that meets the general criteria and we missed it and it's not on the list, those people are still covered. I mean, that's what you're really saying. Let me give you my bad example. Let me give you my bad example again, Cindy. Let me give you my bad example. If we said that this law is going to cover all automobile manufacturers, including but not limited to, and we make a list of them, if we've missed any, by saying it both ways, we've covered everything. We're putting some people
Right.
specifically on notice, but we're kind of having a catch-all. And if that's
That's
what you
fine.
want, I can write it that way.
Yeah,
Yes.
I'm
Yes.
fine with that.
That make sense?
Yes.
I'm fine with that. Ask the other
Okay.
end.
Now let me try.
All
Okay.
right, so Sam's gonna work on that, but, may I? Linda mentioned these two other sections. Sam, before,
Yeah,
if
Linda, let
Linda
me
knows
see.
two other sections, then maybe everybody should,
Well,
I
if
don't
you-
have it in
no,
front of me,
Oh, I'm
so-
sorry. If you look at the definition under
I
county
can't look because I
official-
don't have a copy.
Okay, well, I'm going to explain it to you.
Okay, what
Under
page
the
are you on?
definition,
Pages
there's
in line.
page 4.
What page, Linda?
Page 4,
That's what
which
we're
gives
working
you
from.
A, which is local officers or employees, that's at line 68. That's where that paragraph comes in, where you're talking about the language change to include a list. If you look down at line 83, there's B, local elected officials,
Right.
and then C, other employees on line 86, and then there's the criteria for other employees on the following page, on page 5. So I think that if you're gonna come up with a list that's supposed to be all-inclusive for what's considered a county official under the law, I think that the language regarding the list
Should be at the end of
should be
that.
at the end of that.
No, that should be, actually, the list should really be a new subparagraph D in parentheses.
right.
Oh, thank you, Linda.
Yeah, well, unfortunately, that raises another question in my mind, just quickly, where it says other employee on line 86, 87, other employees of the county whose duties involve the negotiation, authorization, and approval of contracts, leases, franchises. Does that include labor contracts, or is that just monetary contracts?
Why wouldn't it include a labor
Well,
contract?
because then you're talking, you might have some union employees that are covered by this.
Okay.
And that would have to be negotiated with the unions.
Well, I think under the current language of the law, the 98 law, I think that's, isn't that in there?
Whether well, I know there was a flurry of emails going back and forth
There's
about
no
whether.
people
that fill
out financial disclosures things.
This is not, had nothing to do with financial
No, this is
disclosure.
strictly who
This is
falls under
about
this law.
who falls under this law about negotiating
There
contracts.
were a couple of other things that came to mind, and I had sent that over to, and I wasn't really thinking about the negotiation, the contracts, but there's, you're talking about somebody who issues a special permit. Does that include the land and claims adjuster for DPW who gives permits to allow people to, construct a driveway on the county road? If you look at little triple I, line 96, the
Yes.
obtaining of grants of money or loans, does that also include an individual who is required to administer a grant, or part of their duties are to administer grants? So I think you really need to think about who you want to include in this local law, and if certain people are included, there may, and I left that question up to our Labor Council, there may need to be some bargaining over the individuals who may be included.
Well, I just want to, and Cora was kind enough to give me this. This is our current ethics law. This current ethics law includes county officer and employee means an officer or employee of Sullivan County, whether paid or unpaid, including members of any administrative board, commission or agency thereof, and also includes any officer or employee paid from county funds. Way broader than the new language. Every employee is subject to our ethics law. It's our ethics law. So I don't think it would be a bargaining issue at all, since they are currently subject to a law that is even broader and includes more people than the identification here.
The only reason I think it would have to be negotiated is because we cannot make a unilateral change to a benefit, and negotiations is considered a benefit, if I'm not mistaken.
The benefit is
You
you're
can't-
above
you
the
can't-
ethics law.
You can't change the terms and conditions of employment, however, if they're subject to the ethics law already, these prohibitions may not extend to them.
Okay,
It
I'm
may
just-
not, and I did provide a copy of our current local law to Labor Council to review. I also provided a copy to Sandy Shattuck on behalf of the Teamsters, because she had raised some questions.
So if you look at the current law and you look at this draft law, look, this may take another rewrite, guys. Maybe you don't want it to be so specific, because our current law seems to include everyone that works for the county. And by the way, I don't think that's a bad thing, that every employee that works for the county be subject to the ethics law. You may not want to limit it.
But in reviewing our local law, if you look at the proposed local law, if you look at the prohibitions, all of the prohibitions are with respect to a county official. So it may be that this document our employees, our rank and file employees, may not be subject to the prohibitions contained in this local law. If that's, you
Well,
know,
if that's the case,
what the intention
I don't
was.
think any of the labor unions would have a problem with that.
Well, if it's
Right, I
defined
think
as
it
county
Yeah, let Sandy chime in on
I
this one.
think that one of the biggest problems that our legal counsel found was that the wording promulgates the ethics board to decide on ethics concern, and there's a potential to enact discipline. And the ethics board doesn't have the authority to enact discipline over union employees, and that was part of our concern.
But the ethics board makes a recommendation to the county, and then it would go through the civil service, the provisions of civil service regarding, any type of disciplinary.
I don't have the section here, but if you've read the law, it's all subject to civil service law and collective bargaining
Yep.
rights. So,
Yeah, I actually have a list, I forwarded that down to Rachel, so if I get anything back from her today, I'll forward it to you.
Okay.
Am I correct also, as we move forward and we appoint an ethics board, being that this document will evolve, they'll make recommendations for changes?
you give them
can.
the authority to do
Right.
that, yes.
Okay.
And whenever this document does change, it will go through a public hearing, and it's changing, it's amending a local
It's
law.
changing the law,
Right.
So is your recommendation that we,
I'm not
Go with the-
recommending.
okay.
I'm not recommending. I want to be very clear, and I know people are laughing at me at this point,
No,
but
I'm not.
We'll let her
not.
argue.
I am suggesting with regard to the issue of collective bargaining, that if you look at the current law, it includes more people, because it's much broader,
So-
than the specific law in front of you. And
So the question is, do we want to retain what we have in the current law and replace the specifics of this law? So that more people are included? I mean, if that
Or
is
the
our
same
intent.
people. It would be
it's
the same
people,
people.
but more than are covered by the law we're looking at now.
the only reason why I raised it was because of the concern of the collective bargaining agreement. I know that when the committee met, we drafted the language that we knew it would be subject to civil service law, because some people have civil service law protection, and collective bargaining agreements, because they have, and I'm not privy to those. So I think the way the law is drafted, people would still be subject to whatever rights they have pursuant to either the law or a collective bargaining agreement.
I think I personally want to get away from is people thinking that they're above the law, that the law doesn't apply to them, and, you know,
Well, look, if you violate the ethics law, you may have rights pursuant to a particular, I don't know this, Linda, you probably know this more than I do, pursuant to a certain agreement. But if you violate a county law, I'm sure there's some level of discipline that you go through even in an agreement, even by virtue of a collective bargaining agreement. It's just saying that it would be subject to it.
But a collective bargaining agreement cannot supersede a law.
Right.
And I'm pretty sure every collective bargaining agreement I've ever seen has a clause in there that says that.
That's subject to law.
Yeah.
So it may be the level of discipline, it may be, the way you go about disciplining the individual and the rights the individual has, but it doesn't mean the individual is not subject to the ethics law. So I think that, right? Yeah.
Alan?
I think a technical revision on line 68, where it says local officers and employees.
68 line or?
Page 4,
Page 4,
line
line
68.
Okay.
Line 68, I think rather than A and B, it should be Roman numeral, little Roman numeral
No,
wrong.
I and double I.
And the first two, I'm not gonna belabor this, but the first two pretty much covers,
Everybody.
everybody.
Yeah.
The first two, are we on county official 6A? Or
Well,
no?
when I say, starting on line 68, what was A, that's now I. So, local officers, employees are defined as the heads,
Right.
and any members of board of directors, county agency, da-da-da-da-da, and two, other employees of such department divisions, head, councils who have policy-making decisions, whether paid or not. I guess the question is, does it also include all other county employees, or?
That's
Well,
under C,
that
line
would be-
84.
Right.
Right.
or 86, rather.
Okay, yes.
Other employees.
Well, that's a limited list by their function, right?
Yeah, yes.
So that might be the only question they just put out there, is whether it should cover every county employee or not.
And that's why I asked whether or not you wanted it to be broader. You know, I ask about, say you have the summer high school or college kid that's here and helping our public works department on, you know, with
The Lake
streets and
Superior Center,
roads or
right.
whatever. Are they subject to our ethics law? They are subject to our ethics law.
They probably should be.
But would
They
they
all
be
come to that
subject to
bar.
our ethics law under the new ethics law? I say the new ethics law, I don't think they would be subject to the new ethics law.
If they're currently covered under the current ethics law, then I think they should be covered under the proposed ethics law.
I think you really need to revisit the prohibitions to see who that should apply to. One in particular, which I have a concern about, is if you look on page, and it's not actually under prohibition, it's under confidential information, on page 12, line 266. My suggestion would be to make that applicable to all county officials and employees. Currently, in the
266, line
current,
12. Page 12, line.
in the current law, all employees are subject to that, and the language is basically, confidential information, no county officer or employee shall disclose confidential information acquired by him or her in the course of official duties, or use such information to further his or her personal interest, or use for profit of himself or herself, or others information about the property affairs, finances, or government of the county of Sullivan. That is not generally available to the public, exclusive of information available to the public under Freedom of Information laws.
I'm sorry. You need it?
I got it.
This is just draft language at this point?
Just draft language, and thank you, Linda, for this, because you see the way that draft language is, it says A, B, and C are the broad categories, these are just some specific, in effect, specific examples. So,
This is a proposed subsection D to,
so you have A, B, and C would still be in effect, which are actually broader than this. And this says, in case you're wondering, here are some specific entities that are clearly covered, so there's no doubt about it.
My concern, I hate to labor this, but if we go back to the line 73 and 74, one of the concerns that we originally spoke of was about determined annually.
Yeah, this doesn't make it
So
annual.
if you're making this D, it's after A.
Well, this would substitute for that, we'd substitute that language.
So are we taking all of A out? Or are we just taking line 73, 74 out in order to allow this?
Starting with line 73, these individuals, the rest of it, everything above that would stay.
Correct?
My understanding would be
Yeah.
68.
So starting at 73 with these individuals?
Whether paid or not remains,
Right.
Right.
the rest of it gets stricken and
Stricken.
moves to D.
And moves to D.
But I would leave in, that last sentence, which starts at line 79,
The term local officer or employee shall not mean a judge, that has to stay.
Okay.
So-
So we strike
so what
from
you're
73
you're
to
striking-
79.
You're striking the last word on 73, the word these.
Uh-huh.
You're going down to the
To law on
the
79.
law on 79 and striking all of that.
Correct.
You would be replacing it with a new D.
D. Okay. All in favor?
No, I'm okay with it, but the word modified, I'm saying that only additions should be.
I think you want to give yourself the latitude. Modify for example, you may just, it may be the same position that has a new title. You may have a new name for an entity. You may have to modify this.
Okay, good. Thank you.
Thank you for your legal advice, Sam.
All right, then we should
Okay,
vote on it.
so I think it needs to be voted on.
That was changed.
I'm in favor of it as modified.
Are we calling the question? Let's be done with this section.
This is the current website.
Aye.
Pardon?
Yeah,
With the 6.
yeah.
I think we better do it.
Okay.
All right, is everybody good with those changes at this point?
Yes,
Yes.
Okay,
Holy crap.
so.
you don't know what it is?
No, I'm good.
Okay.
I just can't believe we all agreed.
Are we voting on the change?
We are going to vote on the change, okay? So what we're voting on is the amendments to A from 68 in the amendments there. So we're going to eliminate from 73 these to law in 79 and keep the last line. That will be that will be the change there. And then we're adding D, what Sam just came up with, specific listing. And everybody is in agreement with that.
Yeah.
Okay, everybody, all in favor?
Yeah,
Any opposed?
9-zip.
Okay, thank you. All right.
One
next.
down.
Okay.
An hour and 5 minutes, all right. It's a record.
This was a big one, though.
But the
This
question
was a
is,
big
which
one.
way? Okay,
As long as it got done.
okay, the next issue that somebody has?
Well, Cindy actually had on her page. Cindy, did you have 2 suggestions? Because I see 101.
No, I'm done.
So,
You're
just to
done.
be
That's further
clear-
down, that's further down.
Okay.
That's somebody else.
101.
Does somebody else have any other,
Yeah, that's,
anybody have anything they want to bring to the table at this moment?
Well, can I just bring up what I just found out
Yeah,
about
I
this?
do.
Yes, sure.
Okay, so my I have 2 versions right here, and I'm not even gonna go with the other ones. But the website version says, from line 249 to 257, on page 12, no elected official shall use his or her official position to take or fail to take any action, da-da-da-da-da. $250 in the aggregate during the past 60 months. Then there was a subsequent version, which I have stamped,
That's the
April
one we're all
9th,
working with, right?
which has 12 months.
Right.
So we have to make sure that the version that's on the website
Gets changed.
is the one that we're all singing from the same page.
I don't know, I have no control of the website. I
Right.
do
No,
know that
you were
12
copied
months
on
is
it, the
what.
version that I
That's-
sent to Lauren, you were copied on it.
Right.
No, I'm saying, I don't know
Oh.
what I haven't seen the one on the website. I assume he's put up the one that we should have. And that change was made the last time you guys met.
Right,
Right.
That's
correct.
right, but what I'm saying is I printed this off from the website this morning, and now I'm going back to the one that we talked about. So I just want to make sure that everybody's working off the same
At this
flyer
table.
sheet.
Right.
Right. So everybody, the one we're
It's
working from on the front
stamped,
says
right?
received
Yeah.
April
April
9th,
9th.
Right.
2013. So we
That's
are all
fine.
working from the same version, and when it gets changed on the website, it will be from this version.
And that we're now on line 263, right? Jim?
Well, we're going to be.
We're going to be wherever we're going next.
I
Right,
just have a
where-
really
where-
quick question.
Cindy, go ahead.
About, page 12, about the campaign contributions, 250 in the aggregate during 12 months. What happens in month 13? Huh?
You start again. It's another 12-month period.
It's a rolling
We have
12
a-
months.
You're always
You're
working within
always
a
in it.
12-month window.
It's a rolling 12 months. The way this is written, if you had a vote today, you'd look back 12 votes, 12
12
votes
months
from
from
today.
today.
If you have a vote.
What about tomorrow?
If you have a
Vote-
vote
12 months from
a
tomorrow.
month from now, you look back 12 months from a month from now.
So the 250's cleared in
It's
in
not
month
cleared,
13?
it's not cleared.
No.
You're constantly looking back. You're constantly looking back 1 year from the day of the vote. Whatever happens within 1 year of the day of the vote. That's what this says.
But Cindy's asking a question, and the answer is yes. If 13 months ago you received $250, and you're voting today
Yeah.
on something where you got $250, 13
You're
months
not under
ago,
conflict then?
there's no violation of the ethics law.
Yeah, so why wouldn't that be for the length of our term? I don't understand that.
Because none of us agreed to that. I'm sorry, I had to say it.
Okay, okay.
I'm sorry.
All right.
I mean, no, that's a loophole right there.
Well, some of
That's
the-
an obvious loophole in my mind. But, go ahead.
I'm sorry. All right, the 101 that you saw, that's
Okay,
101
go ahead.
Code of Ethics, which is line 150, but that's not where the change would go.
Where is it?
It would be right after line 262. I wanted to add, that would be L. I would like to add a section M, small m.
I'm sorry, what page in the line?
Page 12, right after line 262. Line 263 is blank. I would like to insert it there, small letter M. And
Oh,
it's,
yeah, I got it.
and it would read, an elected county official cannot also be an attorney, accountant, lobbyist, or board member representing an entity or entities that receives county funds or tax abatements. Persons who are board members of an entity or entities that receive county funds will not be permitted to serve on that board if such board member's business is hired for such agency to provide services in which that board member or company earns. I have financial profit here, but I'd rather change that. I want to change it to earns a benefit. If it's a detriment, you'll pay me.
Jean, the way this reads now, or maybe I'm misreading it, and this is the first time I'm looking at this, you're saying, you are precluding attorneys, accountants, lobbyists, or board members from running for elected office.
No.
No.
No?
No, it says very specifically that they can't be an attorney and
They can't be an attorney for an entity. They can,
that's getting money from the county.
version is on
Oh, but that-
You can be an attorney
And
and
you
have
can-
your private practice, but you're not getting paid by the county for anything. And therefore you can be on the board. But if you're an attorney working on one of these boards, you can't, and getting monies from those
Gene.
boards, you can't sit on both seats.
Gene,
what?
you want that to apply to
Yes.
all elected county officials or only county legislators? For example, this as written would apply to coroners who are elected.
Say again?
This as written would apply to the county coroners. They wouldn't be able to sit on a board. They're elected as a coroner, but they wouldn't have any, in their elected capacity, wouldn't have the ability to affect anything.
If.
I'm just
If
asking
he's
whether
also
you
a
want,
funeral director.
whether that's what your intent is.
Well, I have a question for Sam.
Wait, can we get an answer on that one
I'm
first?
sorry,
Just
go
hold
ahead.
that for a second.
Well,
Is that the
apparently I
intent?
didn't realize that included coroners.
But
An
it's not
elected
if
official.
there's
But it's-
personal gain or financial gain. If he's a funeral director, there might be a gain. If he's
Right.
not,
He can serve,
He's making money from the county.
can't have a conflict.
I would just, can I just say
Hold on,
something?
hold on, hold on.
Right, in county money.
I understand what, if you're directing it at the county legislature. But we do have those other elected county officials who might, and I'm not quarreling, I'm just asking.
So the
whether that's
question
what you
is the
intend.
intent for legislators, are we looking to hold this to legislators or to all county officials,
Or county elected.
elected officials?
So Sam, let's just say the Center for Discovery, the person on the Center for Discovery Board could not run for county office.
We're not talking about running.
Well, an
They could
elected
run.
official
If they got
cannot
elected-
also be.
If they got elected, they could no longer be on the board. They would have to resign in order to be, as I read this, it doesn't prohibit you from running. What it prohibits you is from holding both positions
Yes.
at the same time.
And that's what I intended.
So
That was my intent.
So that if you got elected, you would have to resign from that board. I understand that.
Yeah, right. You either choose to serve the public
Or the board.
or make a profit.
The question I had is whether you really want it to be broader than just the county legislature.
Yeah.
I have a question for you, Sam.
I mean, I'm just asking.
Yes, it's your turn. Yes, I
When we
do.
talking about, okay, so we talking about supervisors here?
No.
This is an
I
elected
can't tell a town
official.
supervisor what to
No,
do.
I was gonna say because, because
I
Andy
can't do
Boyer
that.
is a supervisor who sits on some boards who, okay, just wanna make sure we're not
I
talking about.
can't tell a county supervisor what to do.
Okay.
And then in the same breath, I would like to tell them that they can't tell me what to do. But I can't do that.
Making sure because he sits on some boards and he also is a supervisor.
Okay.
So if
Okay.
I'm an attorney.
But it's an elected
I
county
said, I
official.
meant town.
Okay.
So if I'm an attorney for an entity that receives county funds,
Mm-hmm.
I'm the attorney for the entity, I don't sit on the board,
Mhm.
and I want to run for county office, can no longer be the attorney for the entity that receives county funds?
You can either run, that's correct. You can either have a county position, or you can be their attorney. You can't be both.
Gene, there is no such definition of a term of elected county official. I'm looking back in B on page 4, we have local elected officials, interestingly, and it defines county legislators, clerk, treasurer, sheriff, coroners, and district attorney. So if you're gonna use a term with initial capitals, probably should make it, well, as I look back, it should be county elected officials rather than local elected officials in sub 4, because that's kind of misleading.
I understand. I didn't put that in there.
Yeah, yeah, and I think, I would recommend that we change on page 4, local elected officials to county elected officials, because local
Right.
kind of conveys the.
Right.
That you're talking about supervisors and everybody
Right,
else.
town, village,
Exactly.
right.
And then having defined
Fine.
that, it would match up with Gene's.
Well, that I have no problem with.
Okay, so is everybody aware of what we're talking about?
Yeah.
It says.
Page 4.
Page 4, line 83.
83.
No, line 80.
No, 83.
83,
This word,
Yeah,
B.
change it to county.
Where we're changing local to county.
Oh, sorry, it's a different
That
one.
makes sense to you?
yeah, because it's.
Oh, you got the new, you got the old one, or the new one?
I don't know which
It's
version this is.
misleading.
The front of it should have this stamp.
It should be stamped April 9th. Received April 9th.
Yeah, that's this one.
I need to ruminate on
Me
this.
too,
I
I need-
am not 100% sure that what the intent is, which I understand, and the way the language reads may come back and not be read the way it's intended. The other question I had
Another
for
draft.
Jean is, hold on, is representing an entity or entities that receives county funds, which I understand, or tax abatements. County, whose tax abatements?
County. I can't control any other tax abatements.
Well,
We don't,
well, we don't have tax
We're
not
abatements, so
No,
that's,
it's just there in case, I guess.
no, we
It's
can't
not
do
the
that.
giving case.
We can't just do that.
Well, we
County
can-
funds, I
We
get.
can delete it in February. Okay.
No,
Gene, the problem with that is the county doesn't grant a tax abatement.
that's what I just said.
Okay.
So,
And we'll define funds.
Funds?
Funds.
Money.
who
In-kind
receives
services.
county-
Any money?
County money.
So if an attorney represents a client that wins the bid to sell milk,
Yeah, maybe funding from the county?
the county buys nuts and bolts from a hardware store.
Mm-hmm.
That's funds under your half-assed definition.
All right, so I'll go with your change.
Finding, or
Funding.
funding makes more sense,
I'll live with that.
County funding?
Yeah,
as opposed to funds, because
Yeah.
anybody could be given, right.
right, that's fine.
All right, so.
And in
we're
eliminating tax
deleting-
abatements?
We have to, because we don't
we
give.
don't get any tax.
Well, we have to
Because we
do that
don't.
by law, I assume.
Right, okay. So it would end with county funding, that line.
Okay, so
Okay.
that's M 263, line 263.
Can I just-
How do we, why are we limiting it to those three positions?
Do you have any other changes? You can add something. Or you can take something, or you can,
I think it's illegal on the surface, but that's fine. Deal with that when the time comes. I think you need to, if you're gonna pick and choose which professions you want to, I think that needs to be vetted and discussed.
I apologize, because there are a lot of conversations going on at the same time, so if you resolve this, good. An elected county official, you are binding, Sam mentioned coroners, you're binding the county clerk, you're binding the district attorney, you're binding the county treasurer. Is that your intent? And,
Well, what am I binding them to?
Under this, the
What do you
county
mean?
treasurer couldn't sit on the board of a nonprofit.
If there was personal gain.
If there was personal gain.
No,
say that.
no.
No, you're not talking about
It
personal
says-
gain.
Well, that's the
Well,
intent.
That's mine.
that would be the next section. I haven't gotten to that point yet.
No, but line 1 would say that the county treasurer couldn't sit on the board of Center for Discovery or Cornell Cooperative.
Do
Or
that.
SASD.
Can't.
I just don't think you can bind people running from
Well-
elected office.
They have to make that choice. That's what I said earlier.
Well,
Well,
remember
it's one thing
though,
to be a board member, it's another
Not-
thing to be the outside professional that the board hires. I mean, that's their livelihood. So you wanna figure out what you're trying, what's the point?
Give us
What
an
is it that you're
example,
trying
maybe,
to
yeah.
avoid have happen? And maybe we can back into the language that accomplishes
There's
that.
way too many conflicts of interest going on, in my
we
opinion.
define conflict of
Yeah.
interest separately in the law.
Isn't it there?
Conflict of interest is particularly defined in the law.
It's perceived or actual.
Right, and that's what the law intends to protect, the perception or the reality. But it's as drafted. So now you're identifying certain professionals. I mean, a lobbyist has to register with the state, and a lobbyist is a legal term, you know. I understand what you're saying about perception, but I'm not sure that this language adds anything to the current language. I'm not trying to discourage you,
I understand.
but I also don't want to get you, into trouble with elected officials unnecessarily.
I understand that as well. That die has been cast. I've crossed the Rubicon. I've already gotten the phone calls.
From the people with
The point is, why are people so worried if they're not doing anything wrong? I don't understand that.
It's not a worry, this isn't a worry, this is a preclusion.
This assumes that people will do something wrong. That's what it assumes, and it precludes. Gee, not to quarrel, but I'm just saying, that's what, this is based on an assumption that people will do something wrong. You're gonna have financial disclosures. If you're really saying that none of you, for example, could sit on Cornell Cooperative's board?
We have to by
Which they
statute.
do.
Can't, according to this.
We have to by statute.
Yeah, you do.
By state.
You couldn't sit on the IDA, but you have to have a member of this board on the IDA. You couldn't sit on a lot of the boards where the boards are set up to have a member of the legislature sit on the board in the first place, so that you have legislative oversight and participation in the board.
Am I getting any type of a benefit by sitting on the Soil and Water Board?
But under this, you can't. Your first sentence would preclude you from sitting on it.
What would you recommend I change it to
I
read?
think that the intent of what they wrote this was where they placed that was in the interest section. Because it's very clear on, when you read earlier on, that you cannot have a financial interest.
Right.
And it defines interest very deliberately. I believe Tony and Bert didn't do that by accident. They defined interest in a very clear, identifiable way. And that's accomplishing what you're trying to accomplish with this section. It's in here. It tells you exactly that you cannot have a financial interest and do these things. And interest is defined very clearly.
So if we're going on page 5, line
read it.
108.
It's right there.
Five.
Employment, gift, service, payment, permit, approval, waiver, authorization.
Ownership
travel,
and all that stuff, you can't have it.
entertainment.
It's in there. It's,
Okay, so let's read it out. Interest means a direct or indirect financial or material benefit accruing to the county official, page 5,
Take
line
five.
108. His or her relative or dependent, whether as a result of a contract with the county or otherwise. A benefit shall include but not be limited to employment, gift, service, payment, permit, approval, waiver, authorization, travel, entertainment, hospitality, gratuity, or a promise of any of the foregoing. A county official shall be deemed to have an interest in a contract of his or her dependent relative, except a contract of employment with the county a firm, partnership, or association of which the county official or his or her dependent or relative is a member or employee, a corporation of such county official or his or her dependent or relative is an officer or a director, or a corporation at least 10% of the outstanding capital stock of which is owned by a county official or his or her dependent or relative. A financial or material benefit shall not include a campaign contribution authorized by law, and an interest shall not include the setting of county official and employee salary or benefits, or an action statutorily mandated upon a county official where there's no other county official authorized to undertake such mandated action. In that event, the statutorily mandated action shall not be undertaken until a county official delivers written disclosure of the interest to the clerk of the legislature. If this language gets to what Judge Ledina and Kane and Conover were, I mean, we had endless conversations about it, is that at some point you make a choice whether you're going to serve on a board if you could be in a position to get inside information that the general public doesn't have, and you're then on that board with this inside information that the general public doesn't have, or you choose to serve, to make a choice in public service. And I think if the language doesn't cover that intent, then a sentence should be added.
That's fine.
If that's what you're getting at.
Yeah, it's just, there's too much perception of non-accountability. It's horrible. And I keep hearing about it all the time. We have to tighten it up somehow, or at least enforce that.
Right, I think your last phrase, Gene, I think is what really we focus on, because what they did is they wrote something that said you can't have an interest. And we've got to enforce that, absolutely. The sentence here would have been just an absolute prohibition whether you had an interest or not, and I don't think you intended to do that. I know you didn't.
I'm not so sure.
I have no comment.
You didn't intend to take yourself off soil.
I'm not so sure.
I have no comment.
I haven't seen any envelopes with cash or anything.
I think.
Okay, let's.
As long as my legal advisors are telling me it's covered,
I think it's.
I'll live with
Gene,
that.
I think it really is covered.
Okay.
Discuss the second
And
part
there's
of
one
the
other
question.
thing that I point out to you, Gene, that this law does that the present law doesn't do. Present law, remember, has this gatekeeper provision in it, which the current law doesn't have. This law authorizes the Board of Ethics to institute its own inquiries into things. It doesn't have to wait for somebody to file anything. So this law is a much more active law than the present one.
Well, that's fine, as long as it's going to be active and enforced. I don't have a problem with that.
And it's
I would think
does it cover multiple boards?
I think you're covered. I would suggest to you that you are covered.
Okay, so do we want to vote on this?
Well, not yet.
Oh, no.
I have one more question.
Okay, wait.
Does this include people sitting on, for argument's sake, a person sits on 4 separate boards?
That's something that is a policy matter of the board. I mean, right now, there's no ethical violation to the board putting them on 4 separate boards, or them being on 4 separate
My
boards.
opinion is that is an ethical violation.
I don't know, as long as their participation on each one of those 4 separate boards doesn't violate the interest provisions and doesn't violate the conflict of interest provisions, what is the problem?
Well, then there has to be more enforcement.
Yes, that's true. That's true. You're looking at enforcing against having an interest. And the draft that the special committee provided you with gives you a good definition of that, and your board is going to have to enforce it.
Okay, before we move on, Annie is about ready to burst here. She has something that she needs
No, I
to.
just wanted to clarify that the April 9th version is on the website, just so you know.
Okay.
It's under the legislature tab.
Sorry, I was looking at the green tab
That's
on the
okay.
front page, sorry.
No,
But that
that's
means
okay.
that there's 2 separate versions
Yeah,
on the
that's
website.
not, yeah, It's on the legislature tab.
So we're in agreement that we're not addressing M any further, and Jean, based on some level of comfort you have, we're sticking with the language, so there's no vote on
That's right.
M.
Bless you.
Bless you.
I
Do you wanna-
still think that there's a lot of conflicts going on, in my mind.
To the extent that you can control people that you place on boards, if their term is up during the time that you are legislators, that is the greatest level of control that you would have as far as appointments on boards. But you can't prevent someone from sitting on 4 boards, or 5 boards, or 3 boards.
Understandable. However, if I perceive that there's a conflict of interest, what are my remedies?
Right?
Okay,
Under
right.
this law.
Under this
well,
law,
Under
we
this
take
law,
it
you
to
have
the
plenty of
ethics
remedies.
Under
committee.
this law, you have one. And
Right.
I would suggest the most important thing that you're going to do is who you select to
For the
sit
ethics
on the
committee.
Board of Ethics.
Right.
What if I have no choice in who is sitting on a board?
No,
If
I'm
somebody
saying-
else does the appointment and I find that there's a conflict of interest?
Then you can
You
report
report to the
it,
board.
or you can ask for an advisory opinion. Well, you wouldn't ask
No,
for the
you
advisory
could-
opinion, but you
you
can
could-
report it and they'll investigate it.
Whoever
That's the
you,
teeth that's in this law that we don't currently have.
the most important thing that you are going to do as a Board of Legislators is appoint the Board of Ethics. And if you appoint the right people, you've given them the tools to work with in this law. You've given them the tools to enforce the ethical requirements.
It's like we're making the Supreme Court, if we put the right guy in.
If the people don't put the right person on the Board of Legislators, it doesn't work
I
either.
still don't think that covers multiple boards. That's my opinion.
So, can I ask a question regarding that?
Cora?
If that means that the county legislature is appointing people to various boards, and we notice, oh, here's one person who's on 3 boards that we've appointed, does the legislature, as the appointing authority, have any jurisdiction to limit the number of boards that that person's on, that's appointed
don't
by
vote
the
on it.
legislature?
You don't put them on.
Well,
Right.
Well, the thing is, for argument's sake, we appoint somebody to a board. But Board X, Board Y, and Board Z decide they want the same guy on their boards. Do we have the authority to say no? And apparently we don't.
If they are legislative appointments, you
No.
have the authority. If they're
I'm
not
saying if they're
legislative,
not.
if they're not legislative appointments, the issue really is, go back to that definition that Cora just read. Do they have a prohibited interest? I could sit on a dozen boards and have no interest.
I understand that.
So
But
it,
what about perception?
I don't think I think the perception is not an ethics perception. I think the perception you're talking about is that there are a handful of people who seem to be running everything.
There's your
not-
perception.
That's a perception, but that's not an ethics perception.
Jean
That's a
has-
political
Yeah, I believe
kind of
it is.
perception.
Jean has a specific in here,
That's an old boys network kind
Great.
of perception.
Well,
breaking
That's not
it,
ethics.
breaking it
Hold
down.
on, hold on,
to-
Cindy, go ahead. Sam,
That's politics.
please.
No, Jean has a specific in here. It's not just persons sitting on multiple boards. It's persons who are board members and serving on that board. If the board member's business is hired, to me is the key word, to provide services on which that board member or company earns a benefit. So in my mind, that would indicate somebody that's on a board. They can serve on the board, no problem, serving on the board.
Right.
The glitch is if their business is hired to provide services
for that board.
in which that board or company earns a benefit.
Which
Does that
otherwise
cover
it
it?
doesn't
Covered
go.
covered there, but each of these boards you're talking about should have their own conflict of
That's-
interest policies that would preclude
You
that.
can't
We
control
can't.
private
If they're,
enterprise.
if they're
They
not,
get county funding.
if they're nonprofits, for example, it's precluded. A nonprofit can't hire a board member to provide a service.
That's right.
We're talking receiving county funds. We're not talking nonprofit.
Number 9
nonprofit.
covers that.
Number 9 covers that.
Number 9 covers that they're,
On page 5, number 9, what
Interest.
Cora read, covers
Page
that.
5.
So if I am the lawyer, and I'm getting paid to be the lawyer, and I'm sitting on the board, and my law firm is drawing the thing up, I'm gonna get paid, my law firm's gonna get paid, I can't sit there, according to this.
So now with the passage of the law, if you sit on a board and it receives county funds, you will not be able to be hired from such agency to provide services. Okay,
That's what it says.
Yep.
That's what number 9 says.
okay,
Well,
got it.
as long as it's enforced, I don't have a problem with it.
Well, again,
It will
by,
be with the board
by
in
putting the
place.
ethics board in place, you have a place to go to.
It will be if we can get people to sit on the ethics.
Right, exactly. If we can find anybody pure enough to sit on it. Okay, all right, so is everybody comfortable now? We're not going to do anything with that paragraph. Is everybody comfortable with the fact that we're not doing anything with that paragraph?
I'm not comfortable, but
Yeah.
Okay.
if it's a vote.
Oh,
Net-
are we gonna go to not N on this page? Because I just got something
On-
from Cora, but there's an
Wait.
N.
That's it.
Okay, so let's go
Where's
to
that?
page
Yeah.
Well, it's basically the same thing.
Yeah, when I talked to Jean. Okay, basically.
This page is done.
No, we're still, yeah, oh,
We're
wait.
on page 12.
Okay.
We're on, still at line
Oh, boy,
263. And this is just verbatim what I read out at the last
this?
meeting. At the,
It would,
you
it
know,
would be
so
M, but
what the
it's
feedback
redone.
I've gotten since then is the same as, well, whether this, let me just read this,
sorry.
okay?
Yeah, there you
It
go.
would be
I took yours.
violation of the ethics law if an employee, county official, or elected official uses coercion, influence, peddling, promulgation, fear, or retribution of loss of job, scaremongering, threats of investigation, loss of business, bid rigging, etc., in order to induce someone to change county policies for the sake of personal gain / benefit. If it doesn't say benefit on this, your draft, please write that in. So my understanding, I
Or
mean,
that happens to be a state law.
We have that already.
yay, okay,
It's
good.
called, it's a state law that's enforced by Jim Farrow.
And that's the whistleblower
It's called
law.
coercion.
Okay, so if you'll see in the margin here on the left, it says whistleblower there. So the part where, I think it comes back to the same issue then, Sam, if this is inserted as, per state law, because my understanding is that if it's, state law, that's one thing, but if you're making the restriction more than state law, it's a home rule issue.
Well, I don't see.
Sam, what I like about this is, we defer to the district attorney. If there's a criminal law on the books, and an individual may have broken the criminal law, violated the law, and violated a local law, the policy is you let the criminal justice system do what the criminal justice system needs to do. In the event someone is either, the district attorney chooses not to prosecute, because he has the absolute authority to determine whether or not to prosecute. This, Sam, puts a little bit of teeth into the ethics law, so that that individual may not have been criminally prosecuted.
Yeah.
However, they are behaving in a manner that may give county officials the right to discipline.
There are some
or-
words in here, however.
I would change a couple
Some of the words.
Yeah, well, that, some of them
Can you put,
are underlined.
can you put electrocution or hanging?
Oh, my God.
Cora,
But let me,
some of the words are,
it's not legalese, I know that.
yeah, are a little vague in the sense of, I'm not sure if you had, if a board of ethics had to bring somebody up on charges in effect, or the appointing authority had to bring somebody up on charges using this. What you're really saying for a county, what is promulgating fear, I'm not quite sure. There are some words that are already in.
Well, think of some of the people who are no longer working here.
There are some words.
4 or 5 years ago, because they were threatened
Yeah,
with their
I
job.
know, I understand what you're getting at. What I'm saying is maybe we ought to look at some of the words that have
can you just look that
definitions
up?
that are accepted because they are in laws that have been enforced.
I'll give you an example. When I went to
Otherwise, go ahead.
Jim Farrell about bid rigging, he looked through this big black book on his desk and said, nope, it's not there.
Well, there is an absolute statute on bid rigging. Pardon? Yeah, I prosecuted people, sent them to jail for that when I was a prosecutor years ago.
Can you adjust this to define, to
This is
allow
good
it
to
to
be
be
added.
Well-
A little language change, I know what
Well,
Cora's
again,
getting at.
you're either gonna have to negotiate this with the unions, or you're gonna have to change the definition of employee.
Well, so that goes back to page 4 or
Yeah.
5 on what we can, with the definition of an employee. What page was that?
Employee goes to everybody.
So then we take out,
Well, we have these kind of things on the books now.
I
I mean, I
think one
understand the
of
referencing is great, but we have the anti-coercion,
And we have whistleblower
anti-bullying, we have
laws and everything
whistleblower,
else,
we've
right?
got layers
We don't.
of protection against these things.
and then they get buried and nothing
But-
happens.
I believe the problem is, not that it doesn't
63.
already, I guess me as a new person coming on this place, even though I'm here, is I haven't seen enforcement.
That's
And
okay.
that's the piece that is of great concern. And that's one of the reasons why I was in favor of the language changes, because I want to see the ethics law enforced.
I would make a suggestion in that
bottom line.
regard, and Kitty, I would make a suggestion in that regard. Some of this really belongs in personnel policy, rather than that, let me give you one example.
If it's buried and not
No,
enforced,
no,
I
no,
want it in the ethics
No,
law.
I understand that. Let me just give you one example. Presently, if you're talking about harassment,
It's not here, but I could add it.
if you're talking about harassment, a defense to harassment under the present federal statute that we have is that, oh, I didn't pick on you because you're a member of a protected class, I pick on everybody. That's technically under the present law a defense. We've been talking a long time about putting our own policy in place that says that no bullying, no harassment of anybody, those types of things, so that we are very clear that you can't get away with that sort of conduct.
We haven't done that.
We haven't done that. That's what should be done, whether it should be in the ethics law or in personnel is something for you to decide.
Well, I'm a legislator, I'm gonna ask for a vote.
Whatever you want, but I just wanted to point out to you that we have some ineffective at present personnel rules that give people a right to say.
With all due respect, Sam, this is what's in front of us right now.
No, I'm not arguing it, I'm just pointing it out to you. You want to do that, that's fine, but then let's be clear on what we're doing so that we don't include the defenses that people presently have.
Well, this should cover that.
That's right.
Do we just have to change the word employee? Is that-
I think that's the end of the day.
I
We-
believe
just
so.
To change it to official
You
or
understand
something?
what I'm saying?
So,
Professional.
so I would just, Laura, I would say instead of a violation of, in that first sentence, instead of a violation of ethics law, if and, just, how about if we started with no employee?
No.
No employee, county official or elected official shall use, and then we can work on,
If you're gonna use the word
We have to take
employee,
employee out.
you either have to change the definition of employee, or you have to negotiate it with all of the unions.
No county official?
No
or
county
elected
official.
okay, no county official.
Let's make it simple.
Okay, so it'd be no county official,
County or elected official
Right.
shall use coercion, influence, peddling,
That's fine.
promulgating fear.
That's
How about
fine.
libel? Can we add that in there as well?
well, hold on one second, shall use.
Libel's written.
Now coercion is a
Slander is
crime,
Coercion
correct?
is a crime.
So, I don't know that we can use coercion in an ethics law unless as defined by New York State, you know, I don't know how, I understand what Cora's trying to do and I like it. But I do wanna make sure that
Coercive, how about coercive conduct?
well, how about if we take out coercion?
No,
Let me just,
coercive,
hold on one sec.
Coercive
If we didn't use coercion, we continued influence peddling, fear of retribution or loss of job. I don't know what I know what scaremongering is, but I don't know that we want to put that, or threats of an investigation. Now, that's an interesting one. Loss of business, I don't understand. Bid rigging. So what you're trying to say is, I don't want any county official,
To threaten anybody.
right, verbally or otherwise, to put the fear of God in some other county official because they're gonna get some personal gain out of it or whatever.
Slash benefit.
Or benefit, right. Slash benefit, I got the copy with benefit on it. So, if I'm suggesting if we said, no county or elected official shall use.
Well, I think
I don't
the
know
word that I liked that Sam used was
Coercive behavior.
coercive conduct,
Conduct.
such as,
Coercive
behavior such
That's
as.
right.
conduct such as. Okay, again, from the top. No county or elected official shall use coercive conduct such as influence peddling, promulgating fear. I don't know what promulgating, but I think you're trying to, that's not promulgating. but
Threats.
Threat? How's threats of fear?
How about just
Fear.
threats?
How about
Just threaten?
Just threats.
Threats of retribution.
retribution?
No, threats, fear of retribution could be different. A threat and a fear of retribution could be different,
Threats or fear.
right? So we're gonna have
Retribution.
that threats, fear of retribution.
No,
loss of-
threats or fear of retribution. Threats of retribution or fear of retribution or.
Somebody doesn't have to threaten you with retribution.
True.
But you might be afraid of retribution.
I'm-
You wouldn't necessarily be.
And my suggestion
threat-
is that it's broader. Why is it only a threat of retribution? Why
No,
wouldn't it
threats.
just be a threat?
Threats,
Threat or fear of
comma.
retribution.
Yeah,
Threats,
comma, that's what I
comma,
have, right,
Or
well,
fear of retribution,
Good.
Good.
Okay.
Of retribution.
comma,
Loss of job.
comma.
Now, scaremongering. Isn't that threats or fear?
Yes, so get rid of that. Strike it.
And isn't that
Hold on,
coercive
could we go-
conduct?
Now, these are examples of coercive conduct now.
I know, but
Yeah, I think
scaremongering in a law, I don't know.
Scaremongering is too much of a street word to put
So that's why I'm
in-
saying if it's
in an
covered
ethics law.
already, I think if you're comfortable, Cora, we may not need to have
Too
that
much
there.
street language to put in.
Well, I'm not a lawyer. Shall use
why I
coercive
don't like it.
conduct such as influence peddling, threats, fear of retribution.
Loss of job.
Loss of job.
Threats
Do
of
we take or out?
Investigation.
I'm
Or
gonna
loss
take
of
out all
job.
the
Okay.
ors and it will
Okay.
be
Threats of
or.
investigation.
Threats of investigation. Now,
Well,
what
but-
does that mean, a threat of investigation? Because I can tell you,
God bless us all.
if I am concerned about your conduct, I think that's something, and I say, somebody may investigate this. I don't know that should be a violation of the ethics law. So you want to be careful, because someone could be saying to another person, hey, this could be investigated, and you could talk that person out of doing something.
Well, I've heard of, since I became legislator and even before, that people are threatened with investigation for basically not having done anything wrong.
But
So
the
they're
investigation
using
will
this-
show that.
Pardon?
Sometimes, I mean, we've done investigations around here which show that there was no basis.
Right, so
But-
people use threats
Yeah, but-
as the first order of business.
But you don't want to prohibit somebody from saying, we're going to investigate that if there's a reason for it.
I mean, it is
Can I-
for the sake of personal gain or benefit,
It's
so
part of a
it-
culture.
Yeah.
All right, can I add, I just want to say, scaremongering,
out.
could we put intimidation there?
That's a great word.
Okay.
Great word.
Thank you.
I will have it in there. I don't know if it's gonna be, you want that instead of scaremongering.
Right,
Well,
intimidation
scaremongering
or
already
threats
came
of
out.
investigation.
So intimidation, threats of investigation, I caution you on.
Or threaten, or threats.
We have
We've already
threats.
have threats, we have threats above.
Intimidation
Well,
covers-
threats
covers
are
everything.
everywhere.
Yeah, that covers it.
Intimidation
And
covers that.
maybe there's one other word
Right.
you put in there, and that's bullying.
Well, definitely.
All right, so we'll get to bullying, but I want to finish with this because I'm making changes, I want to be clear. Loss of business. Now that, there should be no circumstance where a county employee or official is threatened with loss of business. So what is the circumstance you were thinking of when you put that in there?
Did you mean an official trying to threaten an outside business?
Yeah. That's what came back to me.
Do
Right.
you know what, that's totally possible. I think they're 100% right. It actually happened to me at one point, specifically.
Okay,
Yep.
So we're here
That was
because
the-
it's happened to
right.
us.
See, that was the
Okay,
intent.
Yeah.
good.
Where a county official would threaten an outside business.
Right,
From
Okay.
loss of.
Good?
exactly. Yep.
Not
Good.
good.
no,
Not good.
no, not good.
It's good to
I
have it
mean,
in the
good
law.
that
It's
you
not
brought
good
it
to
up.
do it.
Yeah.
Yep.
But threats of investigation, if you want to know the honest truth, when I was campaigning, I was threatened that the work I did was gonna be investigated as a grant writer. And I found that incredibly offensive and had to get letters from Washington DC saying I did what I said I had done. Now that to me is unethical.
I don't know that it is.
We're writing it.
No, you want it to be, but I just want to be objective here. And I don't want it to be personal.
out of the
So
campaign
take it out
context,
of the
which
whole
is-
thing.
Well,
Some-
I was
wait.
not a legislator at that time. I was not a county official.
Okay. Let's say a member of the press comes to you and they say, I hear that when you were down in DC, $85,000 was unaccounted for in grant money.
That's not true.
She's using an example.
It's a bad example.
No.
You are a man, and you came from Arkansas to New York, and you have no ties to Sullivan County. The point is, somebody may say that to you because they've heard that there might be something, and they're giving you the heads up that they're going to be investigating it. I don't think that's a violation of the I don't think that's unethical. I just don't. I don't know if any other lawyer here can chime in, but I don't think it's unethical for someone to say to you, I'm investigating your work at PETA.
I think
Okay.
that using a threat of investigation to intimidate someone is unethical if they don't think that there's any reason for it.
Well, that's a separate issue.
Well, then what's the language for that? Unfounded threats or something.
How would you know? You have to go through the whole investigation to determine it.
Again, it goes against, is it actual or is it perception? And I know the law covers that. It covers, even a perception of impropriety is covered by the law.
Again, I want to go back to a simple one. A member of the media,
I agree with you.
an investigative reporter says, they have a good relationship with you and they just say, hey, I heard some information, my boss told me I have to investigate it, I'm letting you know I'm investigating it.
Well, that's not intimidation. That's a friend giving you a heads up.
Oh, no, no.
You know,
No, if you read
intimidation
the-
can be very subjective.
Sure.
And when we're writing this, I just want, you know, because I don't have the language in front of me, but I just want.
Neither do we.
None of us
That's,
do.
no, that's okay.
We'll have
That's
some of the
okay.
language.
That's
We're
okay.
working on it. Here, just take that.
But my concern is some of the stuff, you're gonna hamstring certain department heads from doing their jobs and ensuring that their employees are doing their jobs, because
I agree.
part of your job as being a department head is to make sure your office is running smoothly and that your employees are doing their job.
But if I,
And
as
that
a
they're not
department
doing
head-
something that is.
Well, if a
If I-
department head has to threaten their employees, the department head's not doing their job.
But it's subjective. A threat is subjective. What if I say, you know, listen, so-and-so complained about you, so-and-so was at the counter, they complained about you. I have to investigate
That's
what's
not a
going
threat.
on.
You're just stating
But
facts.
my employee may
May
feel
perceive it
that,
as a threat.
that it's a threat.
Perception.
Well, so we're back to square one again.
It goes both ways, that's the problem.
Or,
Let-
All right,
let-
let's take investigation.
Yeah, well,
Well,
yeah, because-
let's hear what a union
because
person
you
has
know
to
who
say.
else is gonna be doing a lot of investigating?
I'm sorry?
You know who else is gonna be doing a lot of investigating? Board of Ethics. They're gonna be calling people in.
Well, that's what we want to
Yeah, but I'm saying.
curtail. We don't want people saying, oh, I'm threatening you with an investigation, I'm taking you to the Board of Ethics for a frivolous.
I mean, that's fine.
Well,
Let 'em do
wait,
it.
No, it's
we
not.
Let 'em
have
do it.
addressed that. We've addressed that because
Right.
in
It's
the
a
law,
frivolous thing.
that's right, and they have to sign it and have it notarized, that
Right.
it's in good faith and that there are consequences.
All right, I'm willing to take out investigation and add bullying.
Okay.
All the way up.
Okay.
There we
The
go.
art of compromise.
Excuse me, for 1 second. Sam, you have something to say?
I was gonna talk about, almost on the exact same line of Linda's
Linda.
thing, is that, you know, the employer has the right to conduct a misconduct interview.
Right.
You know, our big thing is that, you know, we do it in accordance with civil service law, but, they have
That's a
that,
good point.
they have that right. So if you're putting in there that they can't be investigated, what's gonna happen is the employee's gonna come to me and say, under the ethics law, they're not allowed to tell me that they're investigating me, which they are, they're allowed to suspend. if the for 30 days pending an investigation prior to all that. So putting that in there that way is gonna send me and all the employees to the ethics board instead of personnel or Linda.
Gotcha. Well, we're
Well,
taking it
that-
out anyway.
or-
Okay,
addition to.
great.
Yeah.
Can we just go back and get up to speed again where we are? So,
Okay, I'm
we'll-
gonna read so far what I believe we have. No county or elected official shall use coercive conduct such as influence peddling, threats, fear of retribution, loss of job, intimidation, bullying, and now we're at loss of business,
Okay.
bid rigging. Is that a
really
loose?
separate.
So what is bid rigging?
Bid rigging is really separate.
Is that a
Bid rigging
violation
isn't
of-
an intimidating act, it's a conspiratorial act.
It's a crime.
Yeah.
There you have it.
It's probably, Cora, I'm
Yeah.
not sure it's what you want in there, because this is not an intimidating concept. This is totally separate. It's where two people get together to rig the bids on county contracts. That's in and of itself a problem. But it's not coercive conduct.
Well, then we put bid rigging first. Shall use bid rigging, comma, coercive conduct such as.
No, well,
Just put bid
this is
rigging
no
first.
county or elected official. So you wouldn't have a
Shall.
county or elected official involved in
Undertake.
I mean, I guess you could.
But most bid rigging of government contracts frequently involve government officials.
So it would be,
Okay, here's my
Nice.
suggestion.
go ahead, Cora.
No.
In my experience.
No employee, county official, or
No.
elected official, whatever it is, we're
Yep, yep.
taking it out, shall engage in bid rigging, comma, coercive conduct such as colon.
Okay. No, shall
Engage
Oh.
in bid
bid
rigging,
rigging, wait, bid rigging,
comma,
These little three to make it work.
or any coercive conduct such as,
colon,
how's that?
yes.
Or, well, just coercive conduct such as colon, personal gain or benefit, you're actually making it broader. And it's not limited to only county policies. It could be a county contract, it could be a county appointment, it could be other things. So it would actually, I think, help what you're trying to do and by making it a little broader.
You say county policies, what were the other things you said?
I'm just going to pick up with loss of business.
No, you said change county policies or, and you listed 2 or 3 things.
County contracts, you said.
Oh, these are
Yeah.
just examples,
Contracts, yeah.
contracts, appointments. That's why I'm saying, instead of limiting it, why wouldn't you just make it a
broad, yeah.
violation of the ethics law if you engage in any of that for the sake of personal gain?
As long as it's covered and it's, you know,
As long as it's broader and
I know
not
where
more
you're
specific.
Sam, I
Read your-
suggested
read
that
your again.
instead of,
Sorry, I missed something.
yep, after loss
got
of
1 minute
business.
till noon.
Okay, instead of loss of business, after loss of business, under Cora's language, it says, in order to induce someone to change county policies for the sake of personal gain or benefit, my suggestion is, all of that, ending at loss of business for the sake of personal gain or benefit should be broader than just,
Yeah.
and I think it accomplishes what she wants to accomplish a little bit more broadly than the current language.
Whatever you want.
Yeah, it's all in, put it in. I'm good with that.
Okay.
Can we take a vote?
Hold on one second.
I'm gonna read the changes, hopefully clearly enough, and bear with me.
I did this, so
Oh,
if
you
that's
did it?
helpful.
I'm gonna read Scott's changes. No county or elected official shall engage in bid rigging, or any coercive conduct such as influence peddling, threats, fear of retribution, loss of job, intimidation, bullying, loss of business, for the sake of personal gain or benefit. All those in
I
favor?
think it's covered. I think it's covered.
Can I take it?
Yes.
9 zip.
Okay.
Thank you, everybody.
Thank you, and that is going to be included on page 12,
As
starting
added.
at 263. Thank you.
Thank you.
Okay. Is there anything else that anybody has to bring up at this point, or are we finished?
We are not
Cindy,
finished.
hold on.
I
No.
just wanna clarify something. The law now, once it's passed, right, where does it land up? Because, you know, in the Code of Ethics here, it says these standards of conduct, are set forth in the Sullivan
page are
County
you on?
Employee Handbook. Page 7, distributed to each employee at his or her orientation center. I know that's the Code of Ethics, but what do we do with this law? Is this gonna be the same? Is it gonna be on the shelf? Is it gonna be handed to, you know, how do we determine that?
Okay, so I can get to it. Under distribution, we provided for electronic distribution. Under the current draft of the law, I believe electronic distribution, but that Annie, I believe it's Anne Marie, gets confirmation by everyone who's subject to the law that they have gotten a copy of the law, or they've been able to read the law.
So they have to
etc.
acknowledge that they received it, read it, understand it.
Right, and I don't know if we did a form letter. Do you recall that?
Yeah, it was a
I think
simple
we did a
email.
formal, and we wanted their signature on it so there
Yes, I
could
remember.
be no
Part of their file.
confusion
Forms,
as
I
to
remember.
whether or not they received it.
Okay, that's all I wanted to know.
Okay.
So they're gonna know who they are and what's
Yeah, but
expected.
hold on, guys. I know these are your changes, but there's still a couple of blanks in the law.
Yes, there are.
What page?
Page 3. Agencies. Under the current proposed language, the list of agencies subject to the law shall be determined annually by resolution of the county legislature. The initial list of agencies shall be determined by resolution of the legislature within 60 days of adoption of the ethics law.
Where are we?
This
Page 3.
is in an email, when I read from red line to regular copy, this is the language you agreed on the last time. I'm bringing it to your attention that you're going to, within 60 days, you'll need to come up with a list of agencies that are subject to this law,
Like the individuals.
like the individuals within
Okay.
60 days. Okay, so that you're good with. Anywhere where it said local elected official, I will now be replacing local with county, as mentioned. Okay.
Find and replace.
Control F.
Sometimes can be disastrous.
Okay.
Page.
Control F.
Page 8, B, starting on 165, have you reached a decision or conclusion with regard to
Oh,
the tax auction?
Auction.
I think you need to address, we have that list
Yeah,
of
I thought it was
folks.
I thought it was in the email, was the list of folks that Ira's office and Linda's office.
It was in a letter from the Office of Real Property Services from 2006. I don't know that it's been
Here
changed.
it is, this is it.
Well, can we do it as an addendum? The lists, these lists, they are an appendix or
As cited
appendices?
there,
It's,
Is
the
that
only
done?
recommendation he had was
I
that.
don't know how, it was just distributed. I don't know how it worked.
Yeah, I don't know if they actually did a resolution.
No.
I don't think so.
Initially, no.
Oh, this is something.
This is the annual auction that treasurers and real property came up with people who can't bid.
Yep.
Say,
So it's, actually, I'm sorry that nobody from the treasurer's office is here because Ira mentioned to me he's uncomfortable with, he thinks it should be narrower than that. and
I agree.
He
I agree
wanted
it
to
should be
eliminate
narrower.
Department of Public Works employees. The list is A through M, and this is the list that I got from him. And he was uncomfortable with Department of Public Works employees.
Now, the only reason why I can think they're on there is we also have a surplus property auction for our cars and trucks and equipment. So that's
Yeah.
why they, you know, should they be precluded from bidding at a tax parcel auction? Maybe not, but they should be precluded from bidding
And vice versa,
And
people
vice
from my office shouldn't be precluded from being able to bid at a surplus equipment auction.
Right. It's just to eliminate the perception that you have insider knowledge and take stuff off the market before it reaches.
Okay, so, to be clear, the language says no county official may bid or acquire or purchase, etc. And then an exemption.
Why were we adding that exemption for agency board members?
Do you remember what Judge King, you guys were talking about that, do you remember that one, Linda? Because I think he thought it was too broad.
Yeah.
So agency board members that get county funding.
I think it may be too broad to include county official, because, you know, there are many county officials who have nothing to do with the real property, either the administration of the,
I understand where we're all going with this, but I believe, again, the perception is that regardless of whether you are actively or firsthand involved in that, the perception is that you might have the inside information as to make a lower bid, or you know ahead of
We
time.
have to make a higher bid.
Whatever,
Well, no,
you know my point.
It is an
You want as
auction,
many people
so.
at the auction as you can get.
I understand.
I
Bid up
think
the
that was
price.
the reasoning behind it, is you're actually, you know, going to the auction, you're gonna be bidding. So it's not like you can necessarily rig the bid. I think it was just basically, you don't wanna do anything to cause that, let's talk about real property. Let's say somebody from my office is interested in a piece of real property and for some reason either, you know, does something with it with respect to the assessment rolls, and the property owner fails to pay the taxes, so he's got inside information that it's really a 10-acre lot as opposed to a 1-acre lot. You know, so that individual shouldn't be allowed to participate in the bidding process, because they have information that the property is different than what we portray it as.
Are we good with the rest of the law as it's written?
Wait a minute. I know you guys want to get out of here, but if you want the public hearing to go forward, I have to make sure you're all
Make your
comfortable
point.
with the law. I've made my point. This language here is very broad. So it's up to you to change it, or do you want to adopt it and preclude every county official from bidding at every auction?
We say that the coroners can't come to the auction.
Or the director of the risk
Are
management?
we disregarding this
We
list?
want everybody to come to the auction who possibly can.
Do you want to
but
codify
it's up.
this list? What do you want to do? Do you want to have this
Did
language
everybody-
refer
this was
to
sent
a resol?
everybody.
I,
You have it.
my question is?
I wanna make it smaller, because I don't see any reason why your county coroner or your risk manager
Well, look
can't
at
bid
that
at the
list.
auction.
Okay, so my,
That's what we're
Make
trying
the
to do.
list smaller.
so, in order to
I would take
accommodate,
this whole section out
okay, guys,
and put it in the resolution.
I know everybody gets antsy, but this is important. In order to accommodate you, what we can do is we can refer to it like we did with the others. Within 60 days, by resolution, you're going to, is, okay? I know you guys are easy now because you want to get out. But
You should be happy, not
I see what's
complaining at
going
this
on
point.
here,
No,
but
we have
I'm not
another meeting
abusing.
to go.
Wait a minute. So we're gonna say within 60 days of adoption, you're gonna pass a resolution which will identify those who are precluded from bidding.
Yes.
Good. Okay, hold on. I'm just going through it.
I think they should,
Did we eliminate that whole
think
paragraph?
about.
Yes, it will.
We're not eliminating it. We are not eliminating the entire paragraph.
To that at this point. Confidential information gained.
So within, you're gonna be busy in the next 60 days, because it's subject to permissive referendum, so in those, I have one other point. In those 60 days, you have some resolutions to pass. Okay.
And who's gonna be preparing those resolutions?
This one's not only included from giving out confidential information. You should
The
probably
penalties
think about broadening it
provision.
to all of you.
Okay.
The penalties provision.
Page.
I'm trying to get to it because a county official came to me and spoke about penalties. 28, 621, lines. If I violate the law, is $10,000 too high for someone who violates the law?
It says up to.
I know what it says up to, but are you comfortable with that language being up to $10,000?
Yes,
Yeah, why not?
because you could, by this language, up
up
to,
to.
you could subject
do it
them to $100.
$100.
Just saying.
Nature of the
And you guys, okay, you're comfortable with it?
Somebody
Six-
was afraid that 10,000 was too much, they called me.
No, he wasn't afraid. He
See-
just brought it up. He said it's a big amount and.
Well, it
Yeah.
depends
And
on
it
how
was on the
egregious
10,000.
the violation
If
is.
it did
Exactly.
happen, I'd wanna make sure that they paid 10,000.
The other thing
Right.
is, if I violate the law and I'm fined $10,000, you all understand that I also am entitled to an Article
Appeal.
78 proceeding
Right,
to
you can
appeal.
appeal.
Budget
Okay.
limit.
That's okay.
All right, lastly, line 651, you're gonna
We have
see
one
the
more after
change.
this.
Okay. Page 29, we talked about distribution of the code of ethics.
Yep.
So it'll be distributed to every county official and employee. I'm putting electronically or otherwise to give department heads the option to either print it out or just
I'm
tell
sorry, I
their.
missed what line you're on.
Line 651.
Oh, okay, got it.
Within 30 days of its adoption. You're adopting it in 3 weeks
Actually,
mi-
it should become 30 days within.
of effective date.
Effective date.
Okay, because you do need that 60 days, and you're going to be doing a lot of things in that 60 days. So it's going to be after its effective date,
Okay.
okay, to be distributed.
That makes sense.
Okay, good. And let me just make sure. And thank you very much.
We have one
I
more thing
don't
after this.
think I have any financial.
And this is gonna be distributed by the department heads?
However you choose to distribute it, if you're going to distribute it, if you want Anne Marie, when it's done, to send it to all department heads, because it's not limited to county employees.
All right,
It's agencies and boards and, so, that's gonna be a list. That's another list.
All right, one more.
Okay, there's one more thing Linda just brought up. On page 12, line 264, number 3, confidential information. It says a county official shall not disclose confidential information or use such information to further a personal interest. Do we want to broaden that beyond just a county official?
Just currently, employees are subject to the confidentiality requirements in the Code of Ethics. I think it's a good idea to include all employees of the county
I thought we made that
under that
change. I had to-
confidentiality.
Not
I
under.
suggested it earlier, but I don't know if anybody made that change or
Yeah.
focused on it.
So
Okay.
instead of county official, I'm just gonna say,
All
an
county
employee of the county shall not.
Well,
An
you
employee
may
of the
also
county.
want to include those county officials that are boards of agency or board members of an agency
They're not
or
an employee,
something
right?
like that. They may not necessarily be an employee, so that's why
Can they be
I
subject?
suggested, well, under the definition of county official.
How about we just say anyone covered by this local, by this ethics law?
There you go.
Shall not,
Core out.
period. Anyone covered by the ethics law shall
Makes
not.
sense.
Yeah.
Yeah.
How about
Disclose
including county
confidential
employees, because when we identify county employees, they're like other employees.
But we have we
No,
now have
they're also
A, B, C.
defined as county employee.
We have
As-
that list A, B,
as,
C, and D that's
employee.
covered by the local law.
Any
Any
person,
anyone, any person
any person,
or
subject to
entity-
the provisions of this law shall not.
Exactly.
Because if you look at the
Core back in.
definitions on page
Thank you.
5, it says number 8, employee.
Okay. Is everybody in favor of that?
Yes.
All in favor?
Nine
Okay,
set.
great. Okay, that seems to be it. Thank you, everybody. I
Thank
think
you
this was a
very
great
much.
session, and thank you,
Motion to
Cheryl.
adjourn.
You're welcome.
Motion to adjourn. Cora,
Kathy, Cora.
Jonathan, 9-zip.